Greetings and welcome to Obstructing Justice, condensed from American Jurisprudence. This is condensed from over 90 different sections of obstructing justice, but we're going to cover them all within this presentation and as rapidly as possible without glossing over any of the prominent details. So, that said, just to remind everyone, this is strictly for the educational entertainment purposes of this YouTube broadcast, not to be used, misconstrued, mispurposed, or otherwise used for anything legal, lawful, personal, private, business, tax, or otherwise. So please don't do this at home. Let's proceed. All right. Starting with Section 1, generally, and definitions. So generally, obstructing justice is an indictable offense at common law and by statute in most jurisdictions. So it's a common law offense. Or crime, I should say. Federal prohibitions against those practices which obstruct justice are found also in federal statutes, but there's got to be a common law precedence for a specific offense. So if there's a cause in common law, then there would have to be some previous precedence. Now let's get to our definitions. We have the gist of the crime. It's an endeavor to interfere. Obstructing justice is an endeavor to interfere with the administration of justice. It is prohibited conduct. As we saw, there's federal prohibitions and there's also within statutes, but in common law. It's acts that prevent, obstruct, impede, or hinder justice. So acts that prevent, obstruct, impede, or hinder justice. Force or threats are neither essential elements nor only means of committing crime. So force and threats are not necessary for there to be any kind of obstructing of justice. So here's our observation. The obstruction of justice is not a single offense, but a category of crimes that interfere with public administration of justice. All right, let's move on to the next slide. Let's see who's joined us in the chat. 420 Wild Dragon, greetings. And hi to you. So Section 3 we're on to here, the offenses involving force or threats. So the key principles. Assault is not required to prove obstruction of justice. So the force or the threats of assault are not required. Actual assault on a police officer is not necessary for an obstruction conviction. Force or threats, neither essential element nor only means of committing the obstruction. So force and threats, not only are they not the only means, but even if they are committed, then they are not necessary for the conviction. So let's look at those legal implications here. A simple assault charge does not merge into obstruction conviction. Conviction for obstruction and acquittal on battery may be inconsistent, where only alleged means of obstruction was physical contact. So there we go. When it was the only means of obstruction was a physical contact, then the conviction for obstruction and acquittal on battery may be inconsistent. So this might be turned over on appeal, one of them. Obstruction in procuring murder is not barred by double jeopardy, despite same factual setting. So obstruction and, geez. So yeah, I guess double life or something. Here we go. Here's our observation. Hindering prosecution is not a lesser included offense of any form of homicide, even if the defendant argues someone else killed the victim and defendant only helped dispose of body. Well, good to know. We're on to sections 4 and 6 here. Conspiracy, contempt, and perjury. So conspiracy. This is with obstructing justice. Conspiracy to obstruct justice. It's a specific offense. Conspiracy to pervert or obstruct justice. There's also federal statutes that apply. The obstruction of due administration of justice in federal court. There's also contempt. Many obstruction acts are also punishable as contempt of court. Contempt applies to obstructions in presence of court. So the contempt could apply to the obstructions in presence of court. Double jeopardy, it's not barred when different elements are required. Wow. So we have here perjury, the independent offenses. Perjury requires materiality. Obstruction requires intent. So perjury is statutory. Obstruction is common law. So because it's a crime, it requires intent to be proven. Perjury must be material to issues being tried. Obstruction only requires intent to obstruct, prosecution or defense. False statement, while not under oath, is obstruction but not perjury. So as we learned before about oaths being administered by someone with particular authority, the false statement, if you're not under oath, cannot be considered perjury, but it may be considered obstruction. We're on to section 7 and 9, subordination and statutory framework. So subordination is a federal statute prosecutes subordination of perjury. Subornation. Okay. I'm not going to even pretend I know that word. So let's hop over here to Black's Law and say greetings to the most beautiful buzzkill. Good evening to all of you. Let me zoom in so we'll see us a little bit better. Strange word. And it's in the S's, so it's going to be quite ways down here. Look, quasi-committee of the whole. Now that's a word. I don't even see it here. All right. This is a scanned document. It'll catch up with us in a moment with the scroll, and then it'll move quicker. All right, there we go. So we're on the Q's. We got to go a little further down here. There we go. And ST. Should be very close. So a little faster here. Jeez, well, maybe a lot faster. Oh, now we're in the T's. Great. All right, here we go. Should be right here. The end of the S's. We'll get there. I'll edit this out of the video. Jeez, a lot of S's, huh? All right, we're very close. This is taking so long I've forgotten the word. Okay. Subordination. Here we go. All right, let's jump in a little bit closer to read this fine tight. All right, and we have here subordination. The act or an instance of moving something, such as a right or claim, to a lower rank, class, or position. Huh. No, wait, that's subordination. Wrong word. Saying that seemed a little familiar there. Goodness. Subordination. It's further down the list. Psych. Subordination. Here we go. Suborn. Secretly to furnish, to induce a person to commit an unlawful or wrongful act, especially in a secret or underhanded manner. Suborn. To induce a person to commit perjury. To obtain perjured testimony from another. Subornation. Wow. So subornation of perjury from 16th century. The crime of persuading another to commit perjury. Sometimes shortened to subornation. Okay, well, now we know the term there. To secretly induce somebody to commit an unlawful or wrongful act. Especially perjury, sometimes just shortened to that. I should have checked the chat. Trying to get someone else to lie Exactly. Close enough. Secretly to get someone to lie is the key of subordination. All right. A good guess, better than mine. Let's proceed. Of course, the dictionary is always the best decider. So, subordination in statutory framework. Now that we know what subordination is, the federal statute proscribes subordination of perjury. Okay. Subordination statute punishes the actual procurement of perjury. The obstruction statute punishes any corrupt endeavor to procure perjury. So they're there with federal statutes to prevent any of that subordination from happening, any corrupt endeavor. The state statutes have a model penal code, misdemeanor to purposely obstruct administration of law. It's prohibited methods, force, violence, physical interference, or, look at this one, breach of duty. That's considered under statutory frameworks here, huh? So prohibited methods is breach of duty. Let's get on to the federal statutes here. It's a crime to corruptly endeavor to influence court officers or jurors. Prohibits injuring officers on account of their official capacity. And the final clause prohibits corruptly influencing due administration of justice. So that's for the federal statutes there, and don't want to be injuring those federal officers on account of their official capacities. The observation: the omnibus clause of the federal obstruction statute is essentially a catch-all provision, broadly construed to include variety of corrupt methods that impede proper administration of justice. So it's the catch-all, the omnibus clause of the federal obstruction statute. Sounds pretty broad to me. Let's keep going. Stubborn nation. There we go. Jack off Jack has it right. We do live in a stubborn nation. So, Captain Jack, by the way, ahoy. So Section 10, federal statute elements and pendency. So our federal statute elements are the prima facie case elements. Existence of a judicial proceeding. So first we need a judicial proceeding to have any kind of obstruction. Knowledge or notice of that proceeding, or, so it could be knowledge or notice, acting corruptly with intent to influence. And action has natural and probable effect of interfering. So you're acting corruptly with intent to influence. So that's the crime there, the prima facie case elements. The nexus required between defendant's efforts and proceeding. So there's a nexus of law, which is right over here. Knowledge of it, existence, all these things here. And the action has natural and probable effect of interfering. So that's the elements for taking a case in the federal statutes here. And the materiality is not an element of obstruction offense. So these are all, I guess, consequential and relevant, but not necessarily material. Then we have the pendency of judicial proceedings. The federal statute requires pending federal judicial proceeding. So there must be some pendency going on for it to be obstructed. Some state statutes apply even with only criminal investigation and no formal indictment. So even if there's just a criminal investigation, there could be obstruction. We hear about this one a lot. We're on an investigation. State statutes are not identical to federal statutes, unlike things like rules of evidence, where often it is. Then actions before initiation of judicial proceedings may not constitute obstruction. So before there's a judicial proceeding, may, because there's some statutes apply even when only an investigation is happening. So check your state. Here's our caution. Federal obstruction statute applies only to federal cases. Obstruction of a state proceeding is not an offense under the federal statute. So there's your caution. This is an important one too, that the federal obstruction statute applies only to federal cases. All right, we're on to 12 to 14 here. Intent. and corrupt motive. So the intent requirements. Bill Thomas says here, officers often bring up the offense of obstruction when people resist their commands. Does their activities count as proceedings? Well, see, now it would depend on your state. If there are statutes that claim, as we saw here, that some statutes, depending on your state, apply even with only criminal investigation and no formal indictment. So you'd have to check state statutes to find that out for sure. So that's a key thing to check by state, because the state statutes are not identical to federal statutes. So that's an important element to consider there. So when the officers bring that up, it would depend on your state. And then at the same time, that is statutory. So if it is obstruction, it would have to be taken up fully on statutory basis, not on the common law basis, meaning that, let's see, we had some other distinctions between the state statutes. Breach of duty, too, also comes in. So they would have to also, you would have a defense there, too, to ensure they weren't in breach of duty claiming an obstruction. All right, so we're on to intent and corrupt motive. The intent requirements. Government must show specific intent to impede administration of justice. This is when the government's going over someone for obstructing justice. Alternatively, the defendant should have reasonably foreseen the natural consequence. The nexus required between actions and intent to impede the proceedings, as we spoke about earlier. No requirement for direct and immediate obstruction of justice. So it doesn't have to be direct or immediate, or direct and immediate. So, and. Corruptly or by threats of force. Statute prohibits acts done corruptly or by threats and force. It reaches all corrupt conduct capable of preventing justice. We saw here the statute had here about violence. What were they here? Force, violence, physical interference, breach of duty. These are under state statutes. You'll find them depending on your state. Force or intimidation is not required if acts done corruptly. So the acts in and of themselves can constitute the obstructing of justice. So, corrupt motive. The government must establish that defendant's conduct was motivated, at least in part, by a corrupt motive. Fact finder must discern motive by direct evidence or inference. Your fact finder would be your jury or your judge if it's a bench trial. Must discern motive by direct evidence or inference, but not consequential. Corrupt endeavor motivates the action, not the means. Even lawful conduct by attorneys can transgress statute with corrupt intent. Did you see this one? This is an important one here. Even lawful conduct by attorneys can transgress statute with corrupt intent. So I guess you could even say that ineffective representation of counsel of your opposing party, if they're even if they claim it's lawful conduct, the statute, let's see here, can transgress with corrupt intent. The intent is corrupt. Corruptly requires improper, evil, or wicked purpose. Interesting there too. Here's a caution. A statute providing for obstruction of justice does not require specific intent to commit the underlying offense. So this is in one particular state here. There's a statute that provides for obstruction of justice, and it does not require a specific intent to commit the underlying offense. I guess that could almost be like constructive obstruction, if that's even correct. Yeah, he said duty. Glad you caught that one. So we're on to section 15, the endeavor and success requirements. There's the federal statute. Success not required. So they don't have to be successful in obstructing justice. Government need not show act actually obstructed justice. Sufficient if act has natural and probable effect of impeding justice, as we read before. It's a natural and probable. Natural, right? Defendant's actions need not be successful to constitute obstruction. Here's our definition of endeavor from the Supreme Court, by the way. Any endeavor, and that's Mr. Supreme Court, any effort to accomplish an evil purpose which the federal statute was designed to prevent. That's an endeavor, according to the Supreme Court. Free of technicalities behind attempt or doctrine of impossibility. It's any effort to accomplish an evil purpose which the federal statute was designed to prevent. So that designed to prevent seems to invite interpretation. State statute, the model penal code, does not use the term endeavor found in federal statute, though. And the federal one, of course, is defined clearly by the Supreme Court. So state model penal code does not use the term endeavor. It includes intentional, albeit unsuccessful, attempts to influence proceedings. It covers conduct designed to obstruct, impede, or delay administration of law. The key legal principles here: endeavor does not require success or even overt attempt. It merely requires defendant made any effort to accomplish evil purpose. Any effort to accomplish evil purpose. Statute designed to prevent obstruction, not just punish successful obstruction. So it's designed to prevent obstruction, not just punish it. All right, we're on to section 16, influencing court officials. There's statutory provisions. The statutes specifically proscribe intimidation of court officials. Crime to threaten, assault, kidnap, or murder a judge. 2 prohibited intents. Of course, there has to be pending litigation, right? 2 prohibited intents. Interfere with duties or retaliate for official acts. State statutes. Picketing, parading prohibition. Wow, state statute prohibits picketing near courthouse with intent to influence administration of justice. Held necessary and appropriate to vindicate state's interests. Does not infringe on constitutional rights of free speech and assembly. Then there's the false information for consideration. The state statute example here, whoever gives false information to court officer for consideration, in quotes here, with intent to influence official functions, applies only to conduct involving third-party contracting with another. Wow. And does not apply to person providing false information directly to court. So let's get this observation here to make some clarity. A statute criminalizing attempts to influence a judge or juror does not violate the First Amendment to the extent it prohibits threats and intimidation, as threats and intimidation are not protected forms of speech. All right. Now we're on to section 17, jury tampering. Oh boy. Captain Jack says the quote, "The Indians vow to endeavor to persevere," appears in the 1976 film The Outlaw Josie Wales, starring, right? Yeah, Clint Eastwood, yeah. Oops. In the movie, the character Josie Wales, played by Eastwood, reads this vow from the newspaper. The phrase, "endeavor to preserve," conveys a message of enduring hardship and showing the resilience in the face of adversity, which is a central theme of the film. Indeed, and should be a central film of us because that's what we're really against of. It's a war of attrition if you really want to look at it in that way. So let's look at this here, the jury tampering, bribery of juries. And just to leave us on this note here from what Captain Jack was saying, the definition of endeavor from the Supreme Court is any effort to accomplish an evil purpose, which the federal statute was designed to prevent. Of course, that's just their terminology of endeavor. So the bribery of jurors, the key principle is offering or paying money to influence jurors' decision, corrupt endeavor to obstruct justice. That comes from our federal statute there. It's a corrupt endeavor to obstruct justice, offering or paying money to influence a juror's decision. Then there's a crime to engage intermediary to bribe potential juror. Of course, that too. The violation occurs regardless of whether the bribe offer was made to the juror. So it's offer. Let's see whether it's made to engage. All right. So it doesn't have to be offered. It's a crime to engage intermediary even to bribe. And then there's persuasion and influence. Corruptly endeavoring to persuade. Endeavor, there's that word again. To persuade a juror constitutes obstruction. Applies even in non-coercive manner if purpose is to influence. Violation occurs whether juror approached directly or through intermediaries. Then there's the false allegations of misconduct. Case example here. Defendant violates statute by participating in scheme to have juror write false letter alleging misconduct that never occurred. Wow. Violation occurs irrespective of defendant's good faith belief. See this? Regardless of a defendant's good faith belief, the violation has occurred. State jury tampering statutes. Prohibits attempt to influence jury venire members as well as selected members. May be confined to conduct designed to influence specifically jurors and persons summoned as jurors. Prohibits communication with jurors other than that permitted by governing rules, and communication must be conveyed with intent to influence juror decision-making capacity. So, stay away from jury tampering. The statutes here are in the state, and the federal ones, I'm sure, are just as bad. We have false or evasive testimony. False statements alone do not constitute obstruction. So that's our warning here. False statements alone do not constitute obstruction. Here are our legal requirements. False testimony as a basis may support conviction under the omnibus clause of the obstruction statute, which is federal. Mere false statements to government agent do not violate obstruction statute, though. Mere false statements. An additional requirement, they must prove false statements obstructed or intended to obstruct justice. And our key definitions, the testimony classifications. Evasive. A witness deliberately conceals knowledge. That's evasive when they deliberately conceal. False. Witness blocks flow of truthful information. So that's false testimony. Evasive testimony. Witness deliberately conceals knowledge. Then there's the refusal to testify when you don't even get the testimony. If it's after immunity is granted for testimony, then that becomes a willful obstruction of justice. And there's the materiality factor. Conviction upheld when testimony clearly material to grand jury investigation. So there's a materiality factor. That is, a conviction will be upheld when testimony clearly material to grand jury. Okay, that's the case. Yes, the testimony was clearly material to the investigation. So if there's, material testimony and evasive testimony here. So we're getting down to the materiality of it here. The conviction is upheld. So 19 to 20, the evidence tampering and falsification. Destroying or concealing evidence is obstruction of justice. So here's our trash can. Destroying or concealing evidence equals obstruction of justice. Here's some of the prohibited conduct. Concealment. Endeavors, remember those are the evil intent. Endeavors to destroy or conceal evidence are proscribed. Distortion. Acts that distort evidence or impede administration of justice. Document alteration. See, this is all part of obstructing justice. Document alteration, altering or fabricating documents used in judicial proceeding. Then there's the limitations and exclusions. What does not constitute obstruction? Well, discovery documents. Alleged concealment or withholding of discovery documents is not obstruction. Abandoning evidence, dropping or throwing in presence of police. That is not obstruction. We've seen it accused of such, but dropping or throwing in the presence of police is not evidence tampering or obstruction. Falsification. With corrupt intent, well, remember the corrupt intent. The evil intent is an endeavor to obstruct justice. So then there's the financial extortion, demanding money with intent to obstruct justice. So we're on to sections 21, 22, the financial extortion in court orders. Financial extortion is using influence with judicial law officials for financial remuneration. Payments of money may constitute obstruction. So using influence with the judicial officials. Agreeing to use influence with a judge, prosecutor, or witness for money. Attempting to obtain money by claiming ability to fix a case. Legal interpretations. Sufficient endeavor. Attempt to obtain money under pretext of fixing a case equals obstruction if it results in persons pleading guilty, not appearing at trial, or not seeking reduced sentence. No obstruction where no effort made to carry out promise. Conduct may constitute other crimes, even if not obstruction. Yeah, extortion, all these other good ones, huh? All right, resisting or obstructing court orders. Federal crime to obstruct court orders by threats or force. Must prove actual knowledge of court order and intentional obstruction. Requires proof of all actual force or threats, inspiring fear of pain, harm, or death. Force may exist, even if no weapon is used. Physical action inspiring fear is sufficient. A physical action. State court perspective. Obstructing officer carrying out court decree equals obstructing due course of justice. Look at this one. Obstructing officer carrying out court decree is obstructing due course of justice. Yikes, don't stand in their way. Officer acting as part of judicial machinery in this context. Interference with court orders considered direct obstruction of justice system. And it takes us to section 23 to 24. I'm going to catch up with the chat. Oh boy. NorCal Vicious says, reading through the congressional records has been extremely enlightening. I learned a lot in there. I'm glad you mentioned that because I'm going to be doing a presentation where we're going to be hearing different sides of that, and I kind of agree with what you're saying there, but I always like to look fully from the other side too, so you always know both sides of what's going on. Just reminded me that I have a jury summons at the end of the month. Every time I renew my driver's license, they get me. Oh boy. Well, we'll see you there with the other 11. The word endeavor comes from the Middle English word endeavoren, meaning to exert oneself or to make an effort. This verb was formed from the prefix en, meaning in, and endeavor, meaning duty. Itself, Middle French word for duty. Therefore, the etymology reflects the idea of putting oneself in a state of duty to make an effort. Right, but it's an evil duty in the federal statute context because its terminology is no longer just a definition of word. So it's a term of art, and in that respect, it's considered an evil deed or evil intent. Oh yeah, the statutory intent is opposed to textualism, which we're going to should be the topic of the next presentation coming up. So make sure you're subscribed. And Fifth Amendment, in what part here are we talking here? Understanding words is useful. Words and terms. So as Captain Jack was mentioning about the word, the term is actually different because the word endeavor means that effort, or you're called to duty, so to speak, in that effort. But in the federal context, it's, an effort to do something evil or wicked. Okay, yeah. For BT, for Bill Thomas, good. Cold beer is great. In the words of the patriot Samuel Adams, that beer is proof that God loves man. Yes, make beer cold again, indeed. Let's proceed. So now we're on to administrative proceedings, sections 23 and 24. There's elements of offense. Here are the required elements. There's going to be a proceeding pending. We talked about this. It needs to be a judicial proceeding before department or agency. Wow, this is even for administrative proceedings. There needs to be a proceeding pending before the department or agency. Defendant's knowledge or belief of the proceeding, corrupt endeavor to influence, obstruct, or impede. So, wow, so even administrative proceedings, you get to obstructing justice, and the success is not required. Effort to accomplish evil purpose is sufficient. There's your endeavor, the evil purpose. And knowledge of unlawfulness not required to convict. Wow. What is a proceeding? Legal definition. A proceeding is a manner and form prescribed for conducting business before the department or agency. It's not limited to trial-like proceedings. It encompasses both investigative and adjudicative functions. It includes hearings, rulemaking, or any action where official action can be taken or may be taken. The key legal principle here is proper inquiry, whether the defendant had corrupt intent to improperly influence. Remember, these are administrative proceedings. This could be, town halls even. Focus on intent, not means employed. So it's not how they did it, it's the intentions. And any endeavor with requisite intent violates the statute. And these are for administrative proceedings, so that would be statutory. And we're on to legislative and pending proceedings. The legislative proceedings are legislative inquiry. It's a proceeding under obstruction statute. So any kind of legislative inquiry is a proceeding. Applies whether authorized by resolution or under a general investigative power. Proceeding before congressional committee, also within statute. So here's pending proceedings, a pendency requirement. Satisfied if proceeding is at stage where process of justice has begun and formal process initiated. May be pending even if no formal complaint filed. Wow. And evidence presented, witness called, and testimony taken is sufficient for pendency. So once evidence is presented, witnesses called, and testimony taken. And is a key word here. So we have some key legal principles. Legislative proceedings fully protected by obstruction statute. Statute designed to protect integrity of all official proceedings. Broad interpretation ensures effective functioning of the legislative process. And here's our application to obstruction. Any corrupt endeavor to influence legislative inquiry violates the statute. So, influence legislative inquiry. Wow, that's broad. Includes attempts to influence testimony before Congress and prohibits conduct designed to mislead congressional committees. Focus on intent to obstruct, not success of obstruction. Wow, okay. So legislation's pretty well protected, it seems. And Captain Jack says here, is law now, love thy neighbor and thy God now? Not sure. Poor Jesus, yeah. You try, we got this shit written down. Report thy neighbor. Yes, that's the new commandment. Section 27 and 29, obstructing agency committee proceedings. The agency proceedings. Federal statute prohibits corruptly endeavoring to influence, obstruct, or impede proceedings before federal departments or agencies. This includes corruptly attempting to influence agency inquiry, prohibits impeding agency functioning by improper means, covers administrative agencies as well as judicial proceedings. Congressional investigations. Any attempt to impede congressional inquiry by corrupt means violates statute. Wow. Includes attempts to influence testimony before Congress. Prohibits conduct designed to mislead committees. I wonder how much this is like infighting too within government agencies. Interference methods. Prohibited conduct. Providing false documents or withholding evidence from agencies. False statements to agencies with intent to impede proceedings. Destroying or altering documents relevant to proceedings. So even in agency committee proceedings, this matters. Attempts to influence witnesses before agencies or committees. Then there's the key legal principles. Again, success not required. Corrupt endeavor is sufficient for the violation. Statute designed as a catch-all provision to protect proceedings. As we saw, very broad. Broad interpretation ensures integrity of governmental functions. All right, that takes us on to sections 30 and 31. Not working, still loading? Yeah, we're working here. Maybe need a refresh. Yeah, we're good here. All right, so sections 30 to 31, false statements and document destruction, false or misleading statements. The key requirement, statements must be intended to impede due administration of law in a pending proceeding. False statements alone may not constitute obstruction. It must establish the nexus to the actual proceeding, and it may be prosecuted under other statutes, even if not obstruction. So false or misleading statements might have other statutes that apply, even if it's not considered obstruction intended to impede. So there may be overlap, but there may not also. Then there's the destruction of documents or evidence. A statutory violation, usually. Destroying or altering documents with intent to impair their use in official proceeding. Includes both physical destruction, like tearing it up and throwing it in the garbage, and deliberate alteration, like changing numbers on a document. Applies to records intended to mislead or prevent use in investigation. Ooh. And intent to impede justice is a key element. So it's the intent to impede justice. We get to witness influence in agency and legislative proceedings. Gosh, Captain Jack, I hate to see you picturing those things, but writing on paper are laws like women driving and putting on makeup. Yeah, but I think you get it backwards. I heard it's, according to Carl Lenz, it was supposed to be a room full of old women writing all these laws. And the gay guys were driving around putting on makeup, but I digress. All right, so we get sections 32 to 34, the witness influence in agency legislative proceedings. So here's where the witness influence is prohibited. The federal statute coverage applies to attempts to influence, intimidate, or corruptly persuade witnesses before agencies or committees. It prohibits preventing witness appearance or inducing false testimony. It covers both direct and indirect attempts to influence witnesses. The scope of the statute is a broad range of conduct, including attempts to influence agency decision-making. Designed as a catch-all provision, again, to prohibit corrupt conduct. So legislative proceedings, witness influence is prohibited. Success not required. Again, the key principle, offense complete upon corrupt endeavor, regardless of success. The attempt is sufficient for obstructing justice. No need to prove actual obstruction. Okay. Focus on intent to obstruct, not outcome. Then there's the protected proceedings, administrative agencies, the SEC, FTC, EPA, etc., congressional committees and investigations. Statute protects integrity of proceedings and fact-finding. Some real honest agencies there, I see. Okay, so we're on sections 35 and 36, obstructing criminal investigations, which are a lot more common. Yeah, indeed, this is all too true, but sometimes the humor is in that sad but true statement. So the federal statute applies before formal charges are filed. So federal statute makes it an offense to obstruct criminal investigation of federal offense. It prohibits endeavors to influence, obstruct, or impede due administration of justice. Here's our key legal principle. The protection extends to investigative stage of criminal process. Ensures integrity of investigations before formal proceedings begin. And the elements of offense, required elements. Pending criminal investigation of federal offense, defendant's knowledge of reasonable belief of investigation, and the corrupt endeavor to obstruct, impede, or influence. Remember, success not required. Attempt is sufficient for offense, even in obstructing criminal investigations. So again, this is something where they say you're obstructing. Yes, it's a criminal investigation. So keep in mind, well, this is of course a federal offense here. The ones they're talking about the corrupt endeavor. But there are statute ones too. These are the federal ones we're looking at here. Let's continue here to state, municipal, and regulatory proceedings. 37 and 39, state proceedings, state statutes criminalize obstruction of proceedings before state agencies, legislatures, or courts. Often patterned after federal laws, but apply within state jurisdiction. Often. Then cover destroying evidence, tampering with witnesses, and false statements. And there's municipal proceedings. The local ordinances. They prohibit obstruction before local boards, commissions, or tribunals. Now, town hall, interfere with municipal decision-making, hearings, or investigations. Of course, this could be flipped, because when they don't allow the public to speak, that is interfering with municipal decision-making, because it's the people's duty to ensure the government is functioning in the public interest. But I digress. Regulatory proceedings. Federal law covers obstruction of regulatory agencies. Includes conduct to mislead regulators and withhold documents. These are your ways of obstructing regulatory proceedings. Mislead the regulators and withhold documents. Frustrates the lawful investigative functions of regulatory bodies. And then there's the administrative rulemaking. Obstructing or corruptly influenced rulemaking process. Includes falsifying information submitted in rulemaking, or, of course, with the rulemaking, destroying documents to impede rulemaking authority. Somehow I think this might be more common than we are led to believe, because, the destroyed documents don't leave much evidence behind unless someone blows a whistle. And Captain Jack says, 7 loves most commonly refers to 7 types of love according to the ancient Greeks, include eros, philia, storge, agape, ludus, pragma, and philotia, and describing a different form of love from passionate romance and familiar bonds. And self-love. The answer is government. That's what I thought. And the last bean bender is here. Greetings to you. So here's our defenses to obstruction. Here's your common defenses. Lack of corrupt intent. No knowledge of the proceeding. The actions are not impeding. There's a good one. The actions weren't impeding. It's free speech. And there's always due process. Those are good defenses. The defenses focus on absence of required elements for obstruction, which was mostly that endeavor. Constitutional defenses may apply depending on the nature of conduct. Criminal law enforcement investigations. It's a federal crime to obstruct criminal investigations. It covers investigations by the FBI, DEA, and other federal agencies. Prohibited conduct. Giving false information, concealing evidence, intimidating witnesses. Interference with federal investigations. Prohibited acts. Acts that impede ability of agencies to conduct investigations. Destroying documents or tampering with witnesses. Focus on protecting integrity of federal investigations. So that's the purpose, is to protect the integrity of federal investigations. All right, we're on to sections 43 to 44, state, criminal, and regulatory investigations. A lot of the path back with white-collar guys, yeah. All right, so we're on to state criminal investigations and state statutes that criminalize the obstruction of justice during state criminal investigations. This covers a wide range of conduct, similar to federal obstruction laws. Here's a prohibited conduct in state criminal investigations. Prohibited conduct, resisting investigators, giving false information, concealing evidence, or interfering with testimony. And then there's the regulatory investigations. There's federal law coverage applies to investigations by regulatory agencies. Includes conduct intended to mislead regulators or withhold documents. So the regulators are being misled and people are withholding stuff, it seems. It frustrates their lawful investigative functions. And the key legal principles here. The state laws mirror federal provisions but apply within state jurisdictions. Mirror. Regulatory obstruction protects integrity of investigations across government levels. And the broad interpretation ensures effective enforcement of regulatory requirements. Takes us to section 45 to 46, the witness intimidation and tampering. Danger, witness intimidation, prohibited conduct, attempts to intimidate, threaten, or corruptly persuade witnesses during a criminal or administrative investigations. Here are some of the methods of intimidation. Threats, physical harm, bribery, coercion. Punishable regardless of success in preventing testimony. Wow. Then there's tampering with informants. Protection of informant cooperation is essential to justice. So you need to prohibit their efforts to intimidate, bribe, or retaliate against informants. It covers informants providing information to law enforcement or regulatory authorities. So this protects the whistleblowers too, I believe. And there's key legal principles. Statutes designed to protect integrity of witnesses' testimony. Broad interpretation ensures effective investigation and prosecution. And the focus on intent to interfere, not the actual impact on the testimony. So whether to actually change it, it was that intent to interfere, which is the obstructing of justice. And we're on to the good one here, the 47 to 48, document destruction and subpoena interference. This is some good stuff here. And last being, Bender says, do you think implied threats count? If that was the intent to impede justice or coerce or do one of those things, then I believe it would. Did Davis already killed the giant? Oh, David, no. It's clearly important to punish obstruction, but broad laws make handy tools for tyrants. And, yeah, indeed, but I think being aware of some of these laws, I see them flipped around to the other way. There's a lot here about breach of duty being obstruction of justice too. And impeding people from investigating the government of wrongdoing is also obstructing justice. So we go to the document destruction and subpoena interference. There's destruction of records. Oh boy. Destroying records with intent to impede an investigation. It constitutes obstruction of justice under federal law. Applies even if records are not subpoenaed. The key element is intent to impede. Criminal or regulatory investigation. Then we get to interference with subpoenas, the prohibited conduct. Refusing to comply with or obstructing subpoenas for testimony or documents. Here's some examples. Evasive responses to subpoenas. Concealment of subpoenaed materials. Destruction of subpoenaed documents. This is designed to protect integrity of legal process. So the subpoenaed documents, like with a subpoena duces tecum, where they must bring with them when they're subpoenaed. The custodian. All right, we're on to section 49 to 50, the grand jury investigations. With Saint One, yeah, David, and the goal. What's a subpoena? Subpoena is when there's a issue to testify or to bring something for the court, before the court. So a subpoena will be served to the one that's there to bring testimony or the one holding the material that's supposed to be brought before the court. So let's see here. We're on to, yes, the grand jury investigations. A federal grand jury is a serious offense. Obstructing grand jury investigations equals a serious federal offense. There's prohibited conduct, influencing witnesses, withholding evidence, false information. Then there's a focus on protecting integrity of the grand jury process. I'm not sure if Bill Thomas said something about the DMV or the DMV ratted him out to go do some jury duty. So indeed, that's something where if he's going there for grand jury duty, that could be terrible because that means that you're going to be stuck there for a very long time. I've heard about people losing their businesses over grand jury duty because they can't get out of it. But I digress. It's your duty. All right, so grand jury investigations. All right, let's look at the federal grand jury here. So the focus on protecting the integrity of the grand jury process. They don't want you influencing witnesses, withholding evidence, or providing false information. The state grand jury, state law coverage may prohibit obstruction of state grand jury investigations. It covers conduct that hinders or corrupts state grand jury proceedings, includes tampering with witnesses or evidence. And the key legal principles here, grand jury investigations considered critical to justice system. Statute designed to prevent interference with fact-finding process and broad interpretation ensures effective functioning of grand juries. So, again, juries are very well protected. Let's see here. Like a lawyer guy, that's cool. I do pure math. Yeah, math is great. It's our job to do the duty. Well, here, I'll give you a special treat. What we like to do here is when there's a question of a word, it's never good enough for me just to give my top of the head assessment of it. You said subpoena, and here it is right here. We happen to have it on the same page we're looking at. It's verb from the 17th century, to serve with a subpoena, to appear before the court or other tribunal. Subpoena the material witness. To order the production of documents or other things by subpoena, duces tecum. Subpoena the corporate records. Also spelled subpoena. Oh. Yeah, but you'll get points off for spelling it that way. Okay, well that was a very quick digression. Let's get back to the text. So, sections 51 to 53, flight, avoiding process, and harboring offenders. Flight to avoid prosecution. Federal offense, travel with intent to avoid prosecution or testimony. Applies to travel in interstate or foreign commerce. Wow. Offense complete upon travel with intent, regardless of actual avoidance. Wow. Avoiding service of process, prohibited conduct. Endeavors to avoid service of subpoenas, warrants, or summons. Then there's concealment or evasion to defeat judicial proceedings. Then we have harboring or concealing offenders. Oh boy, hide now, Anne Frank. Federal and state statutes prohibit harboring those charged with convicted offenses. So don't harbor the convicted criminals. Designed to prevent discovery or arrest of offenders. Wow. And considered obstruction of justice administration. So the key legal principles here. The statute protects integrity of the legal process. It focuses on preventing evasion of the justice system, and the broad interpretation ensures effective enforcement of the laws. Indeed, we could see with the background image here. We're on to sections 54 through 56. Last Bean Bender says, you know how people broke their arms to get out of the Vietnam, like what happens if you do that for jury duty? Well, I mean, it's your duty, so I'm not going to go any further on that one. Let's proceed. Aiding escape and resisting arrest. So aiding escape, obstruction, statutes prohibit. So this would be the statutes of aiding or assisting in escape of prisoners from lawful custody is considered obstruction of justice. Here are some of the forms of assistance. Tools, give them that file. Transportation, if you pick them up by helicopter, or other assistance. Key element, intent to facilitate escape. Then there's the escape from custody. Escape from lawful custody equals obstruction of justice. Statute specifically criminalized unlawful removal from custody. Resisting arrest, legal framework. Acts of resisting arrest may fall within obstruction statutes, especially when resistance involves threats, force, or corrupt conduct. Designed to prevent lawful apprehension. So, lawful apprehension. Okay. 1984, yeah. So we're on to sections 57 to 58. Officer interference and assault. So interference with officers prohibits interference with law enforcement officers engaged in official duties. Prohibited conduct. Conduct intended to impede execution of lawful authority. Key words. Examples: interfering with arrests, searches, seizures, or other official actions. Assaulting officers. Federal and state statutes prohibit assaulting officers engaged in performance of duties. Considered form of obstruction in addition to separate assault offenses. Protects integrity of law enforcement and justice system. Key legal principles. Statutes designed to protect officers performing official functions. And the broad interpretation ensures effective law enforcement with ADHD. Okay, let's continue. Section 59 to 62. Legal process resistance. Resisting execution of legal process. There's a statutory prohibition. Resisting or obstructing execution of the legal process constitutes obstruction. That's in our statutes and the types of legal process. So here's the things that would apply. Search warrants, arrest warrants, and court orders. So obstructing justice would be restricting or obstructing the execution of court orders. The prohibition applies to force, threats, or other means. It's a person, a people, or citizen, or resident. Well, that would depend on the capacity. Okay, so we have obstructing service of judicial writs. So water aboard the Fifth Amendment. Yeah, well, whatever you got to do to get things done. So obstructing the service of judicial writs and resisting execution of legal process. So here's the resistance of legal process. We have statutory provisions, and then we have the prohibited conduct. Preventing or obstructing service of judicial writs, which includes injunctions, restraining orders, and orders to appear. Interference with officers attempting to serve writs constitutes obstruction. Interference with officers. Obstructing officers executing warrants, arrest, or search. Interference with officers serving or executing process. Conduct such as preventing execution, concealing parties, providing false information. Wow. So obstructing the service of judicial writs. So judicial writs might be the summons to appear, those kinds of things, or warrants. Then there's the section 63 to 66, a prisoner rescue and property seizure. Rescuing prisoners. Obstruction statutes prohibit rescuing prisoners from lawful custody. I like that, rescuing. Prohibited conduct, forcible removal of prisoners from officers, vehicles, or facilities. Legal framework designed to protect integrity of custody and judicial process. The rescue of property seized under process is statutory coverage here. Prohibits rescuing property seized under legal process. Applies to property seized through attachment, levy, or execution. Removing or concealing seized property to prevent lawful custody or sale. Wow. Key legal principles. Statutes protect integrity of legal process and court orders. Broad interpretation ensures effective enforcement of judgments. Yes, that broad interpretation is always there. All right. Glad you guys are still with me on this. We're almost to the end here. Section 67 to 70, the witness interference and retaliation, preventing witness attendance. Attempts to prevent witnesses from attending proceedings. Here are the prohibited methods: threats, intimidation, bribery, and inducements. Applies to judicial, legislative, administrative proceedings. Then there's a tampering with witnesses. There's the statutory prohibition: corruptly persuading, intimidating, threatening, or misleading witnesses. There's the intent to influence testimony or prevent truthful disclosure. Applies to proceedings before courts, agencies, and legislatures. So tampering with witnesses, even in the administrations, cannot be done. And retaliation against witnesses. Retaliation for providing testimony or information equals obstruction offense. So even whistleblowers would have protection. That includes threats, physical harm, economic reprisals. Protects integrity of justice process by encouraging witness cooperation. All right, so we're on to obstructing communications and reporting. Sections 71 and 72, obstructing communications to law enforcement. Statutes prohibiting, hindering communications to law enforcement. There's prohibited conduct, endeavors to hinder, delay, or prevent communications concerning commission of offenses. Examples: intimidation or interference with reporting crimes to authorities. So that's one example, actually. Obstructing reporting of crimes. Statutory coverage. Preventing or discouraging individuals from reporting criminal conduct. Wow. That's obstructing reporting of crimes. Some jurisdictions, that's the anti-snitch statute. Some jurisdictions have specific statutes criminalizing interference with crime reporting, designed to protect the flow of information to law enforcement. Key legal principles. Statutes protect integrity of information flow to authorities. Broad interpretation ensures effective law enforcement. Sure. Okay. That takes section 73 to 75. Obstruction by threats, force, and bribery. Let's jump over here to the chat though first. Hey, we got Less TV and Oakland Love in the house. Greetings. This is a social agreement to be governed, yet folks don't know how the Constitution that respects natural law. Indeed. And we have Double E Carolina from Hello from Maine, USA, arriving late. No, glad to, wow, you watch the whole Rules of Evidence series. Excellent. And that's one of those never-ending series. There's always more on evidence. So we have section 73 to 75, the obstructions by threat, force, and bribery. Here's obstruction by threats. Threats to participants equals obstruction of justice. Offense complete with corrupt intent, regardless of execution. All you need is that corrupt intent, not success, not even execution. Targets are witnesses, officers, and jurors. Doesn't mention judges though, huh? Or attorneys. Obstruction by force, physical force, against officers, against witnesses, and against jurors. Intent to prevent or alter testimony or participation. So yeah, you go there with that physical force. That's obstructing justice. Here's obstruction by bribery, offering to give bribes to influence proceedings. Targets are, again, the witnesses, jurors, and officers. Both offering and acceptance of bribes may be prosecuted. Again, I didn't mention the judges. Key legal principle. Statutes designed to protect integrity of judicial process. Focus on preventing improper influence on proceedings. Broad interpretation ensures effective administration of justice. Yeah. And we have obstruction by deception, concealment, and fraud. The obstruction by deception, using deception to mislead participants in proceedings. Here are prohibited methods: false documents, concealing facts, fraudulent statements. Intent to impede justice is the key element. So remember, we're back to the intent. And this one here for obstruction by deception is to impede justice. Obstructions by concealment, prohibited conduct, concealing evidence, witness, or information material to the proceedings. Material meaning it relates to the main focus of the proceedings. May involve directly to the main focus. May involve physical hiding, withholding, suppression of relevant material. Designed to prevent discovery of truth. And we're on to obstruction by fraud and collusion, fraudulent conduct that interferes with judicial proceedings. Collusion between parties to suppress evidence or present false testimony. Wow. And focus on protecting the integrity of the fact-finding process. All right. Wow, we made it to the end here at sections 80 to 90. Oh, we just lump them together here. The office, process, abuse, evidence, spoliation, and punishment. And these are brief sections, so that's why they're all on one slide. The abuse of process of office and process, obstruction by official misconduct, public officials misusing office to impede justice, such as improper interference, misusing the process, protecting offenders, and frivolous litigation. Abuse of office and process, good one here. Obstruction by official misconduct. Then there's the evidence spoliation, the intentional destruction, alteration, or concealment of evidence. That's evidence spoliation. Courts spoliation. Okay, sorry, it's not spoliation, it's spoliation. Courts may impose sanctions or criminal penalties. It's designed to preserve the integrity of evidence. The interference with court personnel. And there's protected parties. The jurors, judges, court officers, attorneys performing official functions. See, now these guys, I didn't see them in the bribery section. That's strange. Prohibited. Threats, intimidation, improper influence, yeah, includes interference with jury selection process. So that's interference with court personnel. Then there's the punishment and procedural matters, the penalties, fines, imprisonment, or both, depending on severity and the means employed. So the penalties can be based on the means, but not necessarily the conviction. Prosecution requires proof of intent and conduct within statutory prohibitions. Defenses may include lack of corrupt intent, absence of knowledge, or constitutional protections. So those are pretty much sums it up in a nutshell right there. And before we go, there is one last thing I would like to know is what does spoliation mean? And that's something we're going to have to look up here. And that's going to be up a bit. Let's see if we get up there a little faster, then we'll check into the chat while it gets into to where we were. Oh, geez, it went way too far. All right, well, that's catching up here. Let's jump over here to the chat. Let's see. My understanding is words such as driver, vehicle, reside all imply one is operating in commerce. Uber driver, truck driver, bus driver, one travels or conveys their automobile or motor home. The thing is that a lot of these terms a lot of these words end up becoming terminology, and when they're applied in that context, there's a standing presumption that they're being used in the terminology, not in the necessary word. Dwell, domicile, chill spot, or what man does. He's one's residence. Well, res is where they say they. Residence is the commercial term there. Again, it's a lot of these terms go way back to feudal times too. So when you look at it from that context, yeah, they're not. If you're going to use them, they need to be. You need to rebut the presumptions that stand as far as the terminological use of them. So again, we're looking for spoliation to find out if it has anything to do with spoil or something else. If I haven't seen that word before, man, it's a lot of S's though. Okay, we're gonna just go from the I's here. L, M. We should be getting close here. Here's solemn. We were on this one here. Solemnity, a formality, so ceremony required by law to validate an agreement or action. State of seriousness or solemn respectfulness or observance. Solemnity of contract. All right, so before I digress any further, let's get to that spoliation. If I'm even saying it right. Oh boy. All right. Here we go. We should be close. Spoliation. That's the word. There it is. 18th century. The intentional destruction, mutilation, alteration, or concealment of evidence, usually a document. Oh, that's a good one. Spoliation. If proved, spoliation may be used to establish that the evidence was unfavorable to the party responsible. The seizure of personal or real property by violent means. The act of pillaging. Ooh, the taking of a benefit properly belonging to another. From the ecclesiastic law here, the wrongful deprivation of a cleric of his benefice. Whoa, okay, so that's a good word there. Spoliation. And that was the term that was being used here in the presentation. I believe that was the one here. Where did it go? Boy, we've been here too long. Did I pass right by it? Yes. Okay. Obstruction by threats, forced bribery. Well, we've been here too long because my eyes are starting to gloss over here. There it is. Spoliation. Indeed, that's how it's written there. So evidence spoliation is the intentional destruction, alteration, or concealment of evidence. That's spoliation. Courts may impose sanctions or criminal penalties and is designed to preserve the integrity of evidence. All right. So now I feel complete. We caught all the terms, no word left behind. I thought she was crazy to talk about, Your Honor. I am not a person. No, it's that's true. How many times was Jesus judged? In 6 hours, there were 6 trials, 3 of them religious, 3 of them civil, and all were still legal. Less than 12 hours for him. Yeah, indeed. I did. Every year I do the trial of Jesus here on this channel, where we go over that. And at the time of his arrest in the Garden of Gethsemane, Jesus was crucified. Indeed, but again, he was really supposed to be acquitted or released because of the holiday. However, the people there decided they wanted him instead, and Pilate, had to wash his hands of that. Again, those people was that obstructing justice? The people were bribed to rise up and make threats against the courts so that justice wasn't administered. So yeah, Jesus would be considered a victim of obstructing justice. Indeed. Well, with that said, I'd like to thank everyone for attending this one here. It's been a long, dense one, but as we see, there's a lot more to obstructing justice than the few things that we hear about in the typical day-to-day news events and crime blotters. So with that said, I'd like to thank you all for coming in here and participating. Salute to you all, and we'll see you all on the next one. Peace out.